Good morning. If we could, everybody, if you would, take your seats. I would ask everybody at this point in time, if you've got your cell phone, to either mute it or put it on silence or vibration mode, as Dave Howe likes to call pleasure mode. Those of you that are coming in on Zoom, we've got over 40 people that are coming in via Zoom. If you would, we'd appreciate if you have your camera on. We'd like to see you. Make sure you're not falling asleep. We're not boring you to death. But really, in order to get a certificate for this, you have to attend the entire meeting, and that includes those of you on Zoom. That's very important. You're here today to do something that's very important to MetroList and the MLS. And so those of you that are coming in for Zoom, if you would, turn on your camera and mute yourself. And before I get started, I want to bring up some very important people. Many of you in these events have heard me say that if it was up to MetroList, you'd be getting water and bread, maybe just water. But we luckily have Stephanie Jeter and Teresa in the back that are going to come up and tell you about what they do, American Home Warranty and disclosures. So give them a big round of applause. And sorry, those of you that are on Zoom, hopefully you've got a cup of coffee at least.
Thank you so much. Thank you for having us. And I love that he calls us important people. It makes me feel really good right now. Anyway, I just will be really quickly here. You guys have a lot more fun things to learn, but just a little update for First American Home Warranty and what we're dealing with these days. We have a lot of people over the years, as a lot of you know, that probably have been in the business that hate our non-covered costs, right? There are things we don't cover when it comes to air conditioning and water heaters and certain things. We've added some new options for that. So please take a look at our brochure. For those of you on Zoom, it looks like this. If you have brochures at home or in your office, they need to have the yellow flag across the top. That is a current brochure. If you don't have one, you need them, let me know. I can get those to you via PDF, email, or hard copy to your home office or wherever you'd like them sent. And those new options are really important to help pick up some of those non-covered costs, okay? Old systems, please add the First Class Plus. First Class Plus, remember that word, First Class Plus, say it like 6 times. If they have an old system, they're gonna want that coverage. It's new, brand new this year. Secondly, we're now doing rekey service as part of our basic coverage. Tell your clients that when they move in, they forget, they don't know it. Rekey service is part of our basic. I also have a V card that is a fantastic tool that you can download onto your home screen of your phone. It has the PDF, it has a contact to me, you can order from it. Makes it really easy to use our product. I have the postcards back there. Everybody on Zoom, just text me or call me at 916-316-0533. Again, that's 916-316-0533. We have to make this fun, right? Thank you so much for having us. And now, Teresa.
Thank you, Stephanie. Good morning, everyone. What's new with natural hazards? Well, basically, AB 38. Most of you are probably very familiar. We have to disclose very high fire severity zones, but now we have to disclose high. Where does this come from? CAL FIRE. CAL FIRE maps out these zones. The best way to look for it in a report, we specifically call it out for you. You don't have to go digging in the report to look for it. It's AB 38, yes or no. But what's the second layer? It's the certification inspection. We now include the fire authority for you. We've done the homework. So just call on me, Stephanie. We're here to help you. We lead with education. Thank you for having us. Thanks.
Have a great time, guys.
Okay, come on, that wasn't enough. Let's give them a really good round of applause. And again, for those of you coming in on Zoom, you're missing, and they've just brought a lot of really nice things for us to eat, keep everybody energized here. And those of you at home, you can take your mask off. They told me I can take mine off when I speak, but all of you at home, you're free to remove your mask. So thank you for being here, and thank you for being on Zoom. Today you're here to receive some training for something that's very important for the multiple listing service. And the multiple listing service, as all of you know, is really where sellers get the most exposure for their properties and where buyers find the most choices to purchase, to fulfill the American dream. And The multiple listing service is the organized marketplace. And the underpinning of that is the MLS rules. And so our compliance staff, and you're going to get to meet some of them, deal weekly with hundreds of complaints. And most of them are easily solved. But when it becomes very egregious, there needs to be a tribunal hearing. And it's a tribunal hearing by their peers. And it has to follow some very specific guidelines so that everybody gets a fair shake. And we've got our attorney here today, and you're going to find out about all of this. But again, I want to thank you for being here because this is an important role. And we need to have lots of you because many times the people, the complainant and the respondent are people that you do business with and that you know. And you may not want to be involved in a particular tribunal hearing. So we need a wide swath of people and number of people so that we can make sure, again, that the people sitting on the tribunal are comfortable and that the people that are there for the tribunal get a fair hearing. So with that said, what I'd like to do is introduce some people. Starting back there in the back, we have Melissa Backey, one of our trainers. Many of you may know Melissa. She does a fantastic job at training. And of course, I'd be remiss if I didn't say, hey, if you need it, take some training. As I'm fond of saying, if you look at any of the pro sports teams, these guys, some of them have been playing, whatever their sport, football, baseball, basketball, for years. But every year they go back to spring training or fall training, and they relearn the skills that they need. And many of us in real estate need to go back and get a training course, learn, once again, how to use Prospector Plus and all the wonderful things that are part of it. So please don't be shy. Sign up for a training class, or one of the things that we find very effective is in-office training. So if you can get several of your buddies together in your office, we'll come in and train on anything that is specific that you need at that point in time. Then sitting down over there, the masked bandit with the back, is Nicole Prim. And Nicole is actually the training department supervisor, and then also she's our liaison to our admin service centers. And then coming on down, we have Cheryl Hara. You might know her, but hopefully you don't receive phone calls from her. Cheryl's in the compliance department, and she'll be in our docudrama that we're going to have here today in live courtroom drama. It's really going to be interesting. And then next to that, to her, sitting at the table, is Bob Greenspan. And Bob's our vice president, secretary of the corporation, also is involved in our marketing and communications that you all receive. And hopefully we're doing a good job of communicating. Communication with all of you and all of the participants and subscribers in the MLS is always a challenge. I can't tell you how many times we send out half a dozen emails, and then I get the call that, I never saw it, Bill. I never saw it. So open up our emails. We try to make sure that we're not spamming you, that we're sending you information that you need to know. Okay, I'm going to introduce somebody a little later, somebody who really needs no introduction. But as I mentioned up front, and Joel, if you would stand up, this is Joel Levy. You'll be hearing from him later. But Joel is the attorney that we work with for all kinds of things, contracts, and you'll find out the role that he plays in the tribunal hearing. And then we have several people that have volunteered to be part of our courtroom docudrama. I guess tribunal is not a courtroom. And that's important because it's not, the rules of being in a court do not apply to the tribunal hearing. But got Steve Galster over here. You know Steve. Paula Swain, here, and Gloria Tovar. And they'll be up here on the dais serving as a panelist, and then it'll be MetroList staff that'll be the respondent and the complainant. Okay, let me see if I'm missing anything. I don't think so. Other than the fact that, again, I can't thank you all enough for being here and taking part in this. And more importantly, MetroList appreciates each and every one of you sending us your payment and being a subscriber. We do appreciate your business. Couldn't do it without all of you. With that said, as I've many times I've had the pleasure of doing this, man who really needs no introduction. Most of you know him and see him out and about, but that's Mr. Dave Howe. And I just noticed, sitting right next to him, somebody you're going to see a lot of today is Veronica Johnson. And Veronica, if you'd stand up. All right. And Haley back here, see, I should have looked at the script. They're all on the script. But I was looking at, and Haley again, hopefully you're not talking to her a lot because she's also part of our compliance department and will take place in our docudrama today. Okay, now, with that said, thank you. Come on, Dave.
Thank you, Bill. All right, for those of you that are Zooming, our producer, Bob Greenspan, had indicated, please select View in Zoom, then click on Speaker, as in Presenter, to see the slides in the full screen mode. Otherwise, you're going to see it in a little smaller screen, and we want you to have the full experience. So those of you that are on Zoom, again, click View, then Speaker, and then see the slides in the full screen format. So thank you, Bob. Appreciate that. All right, I get to talk to you. My name's Dave Howe. I'm the Vice President of Compliance and Client Success at MetroList. Today I put compliance in the first part instead of the client success. And there's an entire agenda of things that we're going to be covering today. All of what you see up on the screen at this point in time. I won't waste any time in jumping right into this. So really, one of the things that I did want to share with you is that in the compliance department and the oversight that I do, we have the blessing of having such a wonderful staff. And again, that's Cheryl, Veronica, and Haley that really make that job really easy. Our goal there is education first. It's always been education first. And we have good working relationships with people who call us. The people who ignore us, you get a little different experience sometimes because you wind up receiving bills and things like that. We really don't want that to happen. And as part of this process, it's important for you to know that there's typically 3 levels of rules violations that occur within the MLS. The first one is kind of a fix-it ticket, what we refer to as the fix-it ticket. These are anomalies or unintentional, sometimes intentional things that have happened in a listing that we may pick up. One of your cohorts out in the field may turn it in or turn it in as a complaint. And we very simply send you a notice to get you to fix that. And really that's just kind of a heads up. The next one is an automatic fine. Automatic fines typically revolve around the 3-day rule. This is a mandatory submission. MLS Rule 7.6, you got to get your listing in within 3 days. Also, you have to change the status on a listing once it moves from one status to another within that 3-day rule. And most of the automatic fines come from this activity. And then as Bill had mentioned, the more egregious violations, which include and I guess we could put misuse in each one of these categories. I think we might put it on the last one here, but key box system use, you will see that in the tribunal that we're going to hold today. The tribunal that you will see is actually a real case that happened some years ago. We've changed the names to protect the innocent, but that you're going to actually see a real showing of that. We have showings. Showing violation are quite readily come up as complaints, and most recently in 2021, the MLS committee created an automatic fine for showing violations, so people that ignore in kind of a less egregious way of showing the property would encounter that. And then misuse of the service. So this is like uses of the service that the service is not intended for. Contractors, tradespersons, people who hold real estate licenses. They come in not using the MLS for buying and selling of real estate. They're using it for a different business purpose, and some of those have resulted in hearings. And one of the things that we did this last year, we've had a lot of time to reflect on some of our inner processes, is the fact that when you get the notices, the courtesy notices or the automatic fines, a lot of folks would get the first notice. So it's a three-step process to fix a violation. And you get a courtesy notice and it says, hey, you've got a couple days to make this correction. When you got the letter, I think a lot of you will agree, the letter had so much information on it you didn't know what to do. Where's the call to action? And there was some limitations with Listing Data Checker, which is the CoreLogic product that we use to generate the letters. And then we had discovered over this last year that there were capabilities to format that letter where we hadn't been able to format it in the past. So we were trying to solve the problem. And actually our CFO, Nancy, who collects the fine dollars ultimately after all this process takes place, says, well, you know, everybody just ignores everything until they get the bill, right? Well, that bothered us, and it was like, why in the heck is that happening? So what did we do? We went out and talked to you, and we asked you why it is that you did that. And a lot of people, the common thread was, I didn't really know what to do when I got the letter until I finally, I just pretty much ignored everything until I got the fine, and then I went in and I corrected it. So, very first audience today, we basically polished this up. It's going to be released here in the next week or so, is a new courtesy notice violation system, and it utilizes heavy graphics. So in this first one, you'll see the citation notice, green, action item, pointing in a direction to do something. Directly to the right are two steps that you need to follow. The first one is correct the infraction within 48 hours. And it's important that you see the 48 hours on there because there's a sequence of color dots that you're going to see. And it has to do with kind of the stoplight type philosophy. So green light, we need you to do something. Work with us, help you, and then help the community that we work within in the MLS, the marketplace, in the representation of good, accurate information out there. The next step is actually one where if you actually ignore that first notice, you see the green and you go, okay, well, I'll get to it, but time slips by. Within 24 hours, you're going to get another notice, and another notice is a yellow yield symbol. And in this one, it comes up and it gives you the two options, and the two options are always either make the correction or provide us with documentation that illustrates why you shouldn't receive a citation for this. And sometimes we work again with that. Sometimes there's issues where we go, yeah, we were wrong, and this should just stop or go away at this point. The illustration here is that you got 24 hours left. The 48-hour clock is ticking. So you have the green light, which was 48 hours. Now you got 24 hours. If you flat out ignore all of this, the next step is actually the final step, and that's the fine notice. And at this point, the ganging's up, and ultimately you're going to get a citation with a bill. The minimum fine for any violation of MLS rules within the category of the fix-it tickets or the automatic fines is $25 or $250. Some of the violations have graduated fines. So MLS Rule 7.6 as an example is a mandatory submission rule. And if you get cited for not putting your listing in on time, you will get an automatic fine. And then ultimately, if we talk to you and we mitigate that or mediate that, and you promise never to do it again, you would get another notice. And this notice is actually color-coded. Whoops, actually I jumped back. Let me jump back here. So you get the automatic fine with the 7.6. And if you have a reason for why it happened and it was an accident, we will do a waiver of the fine. And the waiver of the fine notice looks like this. It has great big arrows on it, and it says, based on the information you've provided, we've waived the fine. Doesn't mean that you weren't in violation of it, which is important to mention right here, but it is important to note that we do work with you and we're not in it to collect the money. We just need corrective action to happen. The point here on the graduated fines is that if within a 12-month period of time you violate that rule again, So I was late getting my listing in once. 3 months later, I do it again. 4 months later, I do it again. 6 months later, I do it again. We know who habitually do this, and we had a hard time stopping that activity from happening. So the MLS committee stepped in and created the graduated fines. So the graduated fines go from $250. If you do it again within a 12-month occurrence period, the fine goes up to $500. If they do it again, it goes up to $1,000, and then that could bring them into your presence at a tribunal hearing to explain to you why it is that they don't have to adhere to the MLS rules. We've never had anybody get to third base on that one, but just so you know, it's relevant for your purpose here today to be trained as tribunal panelists. So we're very excited about releasing this. It's going to be released live tomorrow. This presentation, or this part of the slide presentation, will be released tomorrow in 2 different counties that MetroList serves, and then coming to a theater near you in presentations that will be held throughout the area. All right. So next up, I am going to introduce the lady of the hour. Her name's Veronica Johnson. Veronica is our hearing administrator. Along with Haley and Cheryl, she's also an MLS rules specialist. So when you talk or work with us in the compliance department, you're going to be talking to Veronica, Haley, or Cheryl. They're here. Please be nice to them. I know all of you will be. But without further ado, Veronica Johnson.
Thank you, everyone. I, unlike Dave, need a cheat sheet. It even has my name on it, so I remember who I am. So thank you so much for being here. I really appreciate it. That you make my job so much easier. My name, again, is Veronica Johnson, and I'm the hearing administrator for MetroList. And I'm going to take you through the complaint process and leading up to our mock hearing. So when we get a call or an email, usually a call comes in, they'll want to complain about someone. We ask and prefer that it come over in an email format. Once I get that email, I review it for its for validity, gravity of the offense. And if we feel that it needs to move on, I send out a formal complaint. I send out a formal complaint to the complainant, and I ask for full details, as much time, dates as you can have, also exhibits, emails, text messages, ring doorbells, surveillance videos, anything to help their case and their complaint. Once I get that complaint back, I review it with my supervisor, Dave, and then if we feel that it must go on, we send it over to our legal counsel right away. Our legal counsel is Joel Levy. I'm going to ask him to come up just to give you a brief synopsis of what he looks at when I send him over a formal complaint. Joel?
Good morning. I'm with Hefner, Stark & Maroy. We've been legal counsel to MetroList and to actually SAR. Prior to that, I've been doing this almost 40 years, and I think we've represented either SAR and then subsequently MetroList for pretty much all that time, possibly all that time. So I've been involved with MetroList for many, many years. And as Veronica said, my role, which fortunately is fairly limited in the process, is to assist in what the tribunal rules characterize as initial review. And it's really the hearing administrator's initial review that I'm primarily involved with. When there's a complaint, the rules provide that the hearing administrator reviews the complaint to determine, and this part of it is much like some procedures that happen in a court. The review is to determine whether, if the facts that are set forth in the complaint are accepted as being true, if all of that was proved subsequently, would that constitute a violation of the MLS rules? So the complaint comes to me, not every complaint, because obviously the MetroList staff deals with many, many complaints that never make it to me. Maybe in a year, I look at 2 or 3 or 4 that get to that stage. because the staff can, in some cases, determine for themselves whether the facts support a claim of an MLS rules violation that should proceed further or not. In court, there's similar motions that people file to challenge when a complaint is filed in a court. A judge will take a look, if somebody asks him to determine if the plaintiff proved all of that, would that amount to some kind of a legal violation? Same kind of procedure that is employed here. So that's my role, is to assist the hearing administrator with making that initial review and determining should this proceed. And I will say there are many situations when I've looked at complaints, many times you see on the complaint form, several boxes may be checked. The same conduct might constitute arguably violations of several MLS rules. I take a look because I don't deal with it day in and day out, so I have to go back and look at the MLS rules frequently when they come to me, and read the rule again. Even though on some of them I've been involved in the drafting of it, so you'd think that I would remember, but sometimes it's best to always go back and look at the actual text of the rule to determine whatever the conduct was, whether it's a problem with key box use, listing issues, or other conduct. If that was proved, would it constitute a violation of the rule? And surprisingly, in many cases, my conclusion is it would not. Just like legislatures, and I know everybody talks about there's thousands and thousands of pages of laws on the books, it's hard to cover everything that might possibly come up. So even though I've been doing this for almost 40 years, it's still surprising to me that situations come up that you say, if we draft a contract or do something else legally to provide for some procedure or a rule, and you think, how did we not think of that? So things do come up that aren't precisely covered by the MLS rules. That takes sometimes some interpretation. But recognizing that tribunal proceedings are serious for all concerned, we do take a close look at whether, in fairness to the respondent as well as the complainant, if that conduct might constitute a violation of an MLS rule, we try to take a very specific look at the fairness of holding somebody responsible for a violation if the rule doesn't expressly cover the conduct that's alleged. So in many cases, I take a look and I find that wouldn't be a violation. Sometimes the same conduct may be alleged to violate 3 rules, and I would conclude that it can only constitute a violation of 1 rule. So things may proceed based upon that alleged violation, but people allege violations of rules. In many cases, a lot of the rules, if you go back and look, actually give MetroList flexibility and remedies for operating the MLS. They're not actually, in the law we call things mandatory or prohibitory. There's things that, if something says you shall do this, this, or this, that's a mandatory rule or law. If it says here are things you can't do, those are prohibitory. They prohibit certain conduct. Not all the MLS rules fall into either of those categories. Some of them simply give notice and provide a framework for MetroList to do what it needs to do to make the MLS operate the way it's intended to. So I take a look. I usually provide a memo back to staff indicating whether I would find that there is substance to the allegation, and if that was proved, could that constitute a violation of the MLS rules that are cited. I don't usually go looking for other MLS rules that might be implicated, although if something's obvious, I might indicate that. But that's not really my primary role. I'm primarily looking at what has been alleged in a complaint, and if that's proved, could that constitute a violation? I'll give you a quick example of something that's come up, and more than once. A complaint may come in that an advertisement by an agent says the agent is the best agent in El Dorado County, for example. If somebody alleges that there's an MLS rule that says you cannot advertise in any way that's false or misleading. Well, that's the kind of thing that's subjective, and even if somebody complains about it, I would look at that. Courts have interpreted that kind of language in advertising and mostly said that's not fraud. That's not a form of fraud, which is really what the MLS rule is designed to prevent. Now, if somebody says in an advertisement, I'm the #1 agent in El Dorado County, okay, that might be getting a little bit closer because perhaps there's some objective way to determine that, but even that is probably mostly subjective and probably doesn't fall into the category of being any kind of misleading advertising. Now, if somebody in an advertisement says, I've sold the most homes in El Dorado County in the past 12 months, okay, that is probably objectively something that can be determined. And if it turns out that that's just factually not true, that may be a violation of the MLS rule that prohibits false or misleading advertising. So that's what I would look at. And in the first couple of instances, I would likely find that even if it's proved, that wouldn't violate the rule. The last one, if that could be proved that that was simply not true, that could be a violation of the rule, and at least things would proceed beyond the initial review. Doesn't mean that it'll get all the way to a hearing, but at least we'll proceed beyond it. So that's my primary role, and rarely I get involved later in the process if there's an MLS rules interpretation issue, but that happens very, very rarely, and probably not even more than once a year. So in any event, that's my basic role, and it's limited, and it's usually early in the process, and the staff handles everything from there. And really, I think we've had good experience over the years in getting things resolved. Thank you.
Thank you, Joel. Once I received Joel's findings back, I review them with my supervisor and the CEO. His review is an in-house review, so we do not share it with the tribunal panel, complainant, or the respondent. We may, like Joel says, find that there's additional rules that the complainant didn't know about, or maybe there's one that doesn't apply. So then at that point, I contact the complainant and let them know that we're proceeding with a hearing. At that time, and I've had this on several occasions, I'll call and the complainant will say, I've changed my mind. I want to rescind. I was in the heat of the moment. They called, they apologized. I don't want to go any further with this complaint. MetroList at that point has the ability to continue on with the hearing. We would just be in the place of the complainant, and that original complainant would be rescinded. So then I send out paperwork to the respondent, and I send out a response for them to respond to the allegations. I ask them, again, for all details, emails, text messages, anything they can provide to prove their case that they did not do any wrongdoing or make a violation. So, on occasion, the respondent gets the packet, they call immediately and they say, I'm guilty. I'm guilty, I just want a fine, I do not want to go to tribunal hearing. They're shaking in their boots, I can hear it on the phone, and they just don't want to go. Now, at that point, there's a whole procedure which I'll have Dave explain.
It's called mediation. Thank you. The first thing we do is if we have the opportunity, which we do take these opportunities when they arise, every chance that we can get because we don't want to go to a hearing, is make a call to the complainant and explain what's happening, that they've admitted guilt, and if they would allow or permit MetroList to take it from here on the penalty phase. There is no discussion with anything with regards to the complainant about the action that MetroList takes. We do typically, or it does typically involve a monetary amount and a possible reprimand or probationary letter in their file for a period of time. That typically will satisfy the complainant. The complainant really, in many cases, as having to satisfy an upset seller, as an example. And so really we try to work with all parties to try to work through it. In some of the best case scenarios, you get two of the brokers. If there's agents involved, you get the participants talking with one another, and that usually works out pretty well. If the parties are not agreeable, so make the call, they say, hey, they're admitting guilt, let us take it from here, and they say, no, I want a hearing, I want my day at a tribunal, then we go, okay, here we go. So from there, I'll give it back to Veronica.
Okay, so for purposes, we're going to go to a tribunal hearing. At this time, I schedule a hearing. All of you will be on a list, and that's the panel I pick from that list. And so I send out paperwork. Once we kind of throw out a date, I throw out several dates to you all and see which one sticks. And once we have a date that's cohesive for everybody, that's the date we're shooting for the hearing. So I send out the paperwork to all of the parties, and then I pick the presiding officer, which is kind of the head person, a participant, an alternate participant, subscriber, and an alternate subscriber. For the purposes of this mock hearing, our respondent and complainant would have their broker sitting with them, and then we'd have an alternate and two alternates and our tribunal reporter. But we don't have those today. But normally on a normal hearing, it's a larger group. And so when I send out the notice of the hearing, it goes out to everybody showing the date and time of the hearing and who is a part of the panel, who's the complaint, who's the respondent. At that time, you can excuse yourself. Let's say you worked with this person that is the respondent. You can excuse yourself, and then I pull from the list to take over your spot if you feel there's a conflict of interest. I send out a full packet a week before the hearing to all the panelists in regards to the complaint, the respondent's response, date, time, directions to our office. Now we get to the hearing day. So the hearing day is here. We're at our office, and so I'd like to call up Steve Galster, who's the presiding officer, Paula Swain, who's the participant panelist, Gloria Tovar, subscriber panelist, Haley Garsky, who is the complainant, and Cheryl Ihara, who is the respondent. Thank you.
Welcome, and I'd like to make a couple quick comments. So first of all, when this happens, they're sitting across from us, so this is for camera use only to be in this thing. It does get a little intense, and the script that I'm about to read is read every single time, and it's long. And sincerely, I have brand new contacts with readers, so I may struggle, but hang in there. But this is exactly how we do it. By the way, I have had the privilege of serving with these two before. And we didn't always agree, but in the end, we came to a solution and a remedy, and we'll do that again today. So here we go. Prior to hearing your hearing administrator, ladies and gentlemen, sorry, I was reading too early. I now call the disciplinary hearing to order, which shall be conducted in accordance with procedures for MLS rules violation hearing and the outline of procedure. These procedures for disciplinary hearing before an impartial tribunal comprised of members of the MLS Tribunal Committee to ascertain the truth in this disciplinary proceeding and to render a decision based on the testimony and evidence presented. Please note this is a disciplinary proceeding, not arbitration, and this panel cannot award monetary damages. At this time, I would like to introduce the members of this tribunal. My name is Steve Galster, and I'm the presiding officer of the tribunal. On my left, it's backwards. On my left is Paula Swain, and on my right is Gloria Tovar. As a member of this, the third member of this tribunal, okay, I screwed that up. Of counsel, if applicable, presented to my far right is the legal counsel for complaint. Joel has not been there for me in the past, so am I skipping this paragraph? Okay. Sometimes counsel could be in the room. Counsel should not make direct inquiry to any party or witness, and of course will not participate in any decision of the tribunal. Counsel is present to respond to any questions which may be brought by the tribunal members concerning procedure or the laws of the state of California, and shall not be considered counsel to the parties. Of the parties, I now ask that each of you introduce yourself and your witnesses, starting from my left, and indicate your role in today's hearing. All witnesses should be present at this time.
My name is Cheryl Ihara, and I do not have any witnesses.
And to my right, would you introduce yourself?
My name is Haley Garsky, and I am the complainant.
I want to inform each of you today that the hearing is being transcribed by an independent court reporter, stenographer. Each of you, when speaking, should identify yourself, and please, only one person at a time. No other unauthorized recording may be made of this hearing. Before we continue with this hearing, all persons present are advised that the proceeding and decision of this tribunal are considered confidential. All parties in this hearing are admonished that failure to keep these proceedings and resulting decisions confidential is a violation of your agreement with MetroList. The basis of this hearing. This hearing has been established to consider a complaint alleging the violations of Section 13.6.1, 13.6.2, and 13.8 of the MetroList MLS rules. This tribunal is not a court of law and cannot be governed by the technical rules of evidence. This tribunal shall seek to determine all ascertainable and relevant facts pertaining to the matter under consideration to arrive at a pure judgment and a decision that is fair to all parties. All parties will be allowed full opportunity to be heard on matters relevant to the issues. The tribunal may rule at any time during the hearing on the relevance of testimony being given or questions being directed to any party or to witnesses providing testimony. Parties whose legal counsel is also present may not refuse to respond directly for requests for information or to be questions addressed to them by the tribunal members. Your legal counsel is present to advise and consult with you. However, she may not speak for you, and thus appropriate rulings or determinations have been made by the tribunal. This tribunal will not tolerate any effort by a party or his or her legal counsel to harass, intimidate, coerce, or confuse the tribunal, witness, or any party to this hearing. As the presiding officer, I will act as the keeper of the evidence introduced at this hearing and mark each with an exhibit identification number and date. Interpretation of rules. If any provision of the MLS rules or procedure relating to the tribunal's handling of the matter is involved, the interpretation by the tribunal, including any interpretation of the hearing procedure, shall be set forth as a separate finding and shall be conclusive and final, except that the directors on appeal from the tribunal's decision shall not be bound by the tribunal's interpretation of the MLS rules or hearing procedure. If any issue relating to procedure arises which is not expressly addressed in the procedure for MLS rules violation hearings, the tribunal shall determine and resolve such issues, and such be conclusive and final except that the directors on appeal from the tribunal's decision shall not be bound by the tribunal's determination or resolution. Sorry. Verification of receipt and understanding and acceptance of outline of procedure. Each of the parties and their legal counsels, if applicable, were asked to sign the receipt, understanding the acceptance of the outline procedure. I ask again the parties if you have read and understand the outline of procedure that was furnished to you. If there are any questions or objections that you have concerning the outline of procedure, I should be glad to answer or rule at this time. If there are no questions or objections, we shall assume that your silence indicates your understanding and acceptance of the outline or procedure, and we shall proceed with this hearing. Are there any objections? At this time, I request all persons in this room that expect to testify at this hearing be sworn or make the appropriate affirmation in lieu of being sworn. I ask you to raise your right arm. And the following questions I will pose and answer in the affirmation you do so swear to affirm. Do you swear or affirm that the statements you're about to make at this hearing are the truth, the whole truth, nothing but the truth, given freely without reservation?
I do.
Yes, I do.
All witnesses, please leave the room at this time to your waiting rooms until called to testify. Opening statements. Each party shall be given the opportunity to make their opening statement. If the respondent wishes to wait to give his or her opening statement until the conclusion of the complainant's evidence, that will be permitted. I will now invite the complainant to make their opening statement.
On June 15th at 2:30 p.m., a person by the name of Joseph Smith entered my listing at 123 Main Street. The showing instructions on my listing has always been by appointment only. My complaint is that Joseph Smith entered my property without permission, and Cheryl Ihara gave a key to him and allowed him in without being present.
I will now invite the respondent to make their opening statements. However, if the respondents desire to wait until the conclusion of the complainant evidence, they are so permitted.
Thank you, Mr. Gulster. And in response to Haley's complaint, I didn't give my key to Joseph Smith. I actually opened the property for him and then went to my car. In this crazy market, I never look at the showing instructions.
Each party will be given the opportunity to present such documents, evidence, call witnesses, or give such testimony as deemed applicable to the matter being heard. Evidence may be submitted in the form of written statements by documents or other papers, but the tribunal may require that these statements be verified by affidavit. At the conclusion of the presentation, the other party may cross-examine. The members of the tribunal may question the witnesses, usually when both parties have concluded their examination or cross-examination of witnesses. No testimony is to be admitted relating to the character or general reputation of anyone unless such testimony has a direct bearing on the matter being heard. The complainant may now present such witnesses, documents, evidence, or give such testimony as deemed applicable on the matter being heard. At the conclusion of direct examination of each witness, respondents may now cross-examine. I was ahead of myself.
On June 15th at 2:30 p.m., a person by the name Joseph Smith entered my listing at 123 Main Street. The showing instructions on my listing has always been by appointment only. My client is a single woman and she was home at the time. She came out of the shower and heard voices. She was frightened and went downstairs. Standing in her house was a man and a family of 3. She asked them, "What are you doing?" The man stated that he is showing the home to his clients. My client asked, "Did you contact my agent?" He said, "No, there is a lockbox on the home and my clients loved the curb appeal and we were in the area." My client asked the agent's name and he stated it was Joseph Smith. My client asked Joseph Smith to leave immediately. He had the nerve to show the clients the kitchen and backyard before leaving. My client called me immediately and checked my super report, and the key is registered to Cheryl Ihara, not Joseph Smith. Cheryl Ihara is the broker of the real estate firm. I called Cheryl immediately and she did not show any remorse. I asked her a series of questions. Who is Joseph Smith? Cheryl said that he is an assistant that works for me. I asked her why Joseph Smith was using her key. Cheryl denied that it was the case. She stated that she let Joseph Smith in and was waiting in the car. I explained to her that we have a Ring doorbell video of Joseph Smith entering the property with his clients and there was no one else present at the time. Cheryl seemed as though she did not care. My client is so very upset and I have removed the lockbox for safety. She is questioning the integrity of the lockbox system and can allow non-members to use the lockbox. I have attached the following exhibits. Exhibit A, Super Key Box Report. As you can see, I have the Super Key Box Report showing Cheryl Ihara's key entering the property on June 15th at 2:30. Exhibit B, the Ring doorbell video. I have the still images of the Ring doorbell video showing that the people entering my listing were all male and Cheryl Ihara was not present when the key box was accessed. Exhibit C, letter from the seller. There is a letter from my seller stating how upset she is from the event and how it has now affected my relationship as her agent. I believe these following rules are, the rules that were violated. Rule 9.1, showings not following showing instructions. Cheryl Ihara violated this rule. She did not follow by the appointment only showing instructions. Rule 13.6.1, seller's agent permission entering the property. Cheryl did not have permission to enter this property by myself or the seller. 13.6.2, participant subscriber must be present. Cheryl Ihara was not present on the property at the time, and the seller and I did not give permission to be there otherwise. Rule 13.8, unauthorized use of the key. Cheryl Ihara gave her key to her assistant, and assistant accessed the property without any authorization to do so. Cheryl should have never given her key to another individual. That's all I have.
Do you have any more evidence or anything else to submit at this time?
That's it.
Thank you. How would you like to respond?
Does your Ring doorbell have video of the entire street? I was in my car as I had other business to attend to.
The Ring doorbell only shows the front of the porch.
So I could have been in my car at the property while they were showing the property.
Yes, you could have, down the street.
I have no other questions.
Well, at this time, we will, as the panel, start asking questions. I have several. Would you like to ask any?
How far away? Woke us all up.
Non-union station.
How far away was your vehicle from the subject property?
It was parked directly in front of the home in question.
So possibly with a Ring doorbell, is her vehicle shown in the Ring doorbell?
No vehicle is in front of the house.
I just have one quick question. Can you explain to me how the Ring doorbell did not see you opening the lockbox?
Well, I was sitting in the car and I gave him the key. I didn't think that was a problem since I was there at the property for the showing. No.
Is Joseph Smith licensed?
He is a licensed clerical user.
So he's not a realtor?
Not practicing, but he does have his license and it's up to date.
I'm just curious as to why you would allow him to show the house instead of you, the agent?
Training him to become a licensed realtor and to practice real estate in the future.
And your participation in that wouldn't have been better?
Probably.
So Joseph's not here today for me to ask him why he would not immediately leave the residence when the homeowner obviously is fearful startled and asked him to do so, but yet he continued on to show the house, including the kitchen and the backyard. Is there an explanation for that?
I have not talked to him about that.
Is Joseph Smith still working for you?
Yes.
Is Joseph Smith, so you said he does have his license?
Yes.
So is he under your broker's license at the office?
Yes.
So he is an active
Mhm.
realtor. So in order, did you, forgive me, did you say you went and opened up the lockbox, then gave him the key? Or you gave him your cell phone or whatever, your key box, to open it up?
I had given him the key because I had line of sight to the front door.
You gave him your key?
Yes.
Can I have something? Go ahead.
Is this standard procedure for you? Is this how you usually show, if you have him with you, is he usually the one that's showing the property for you while you're in the car?
No, this is just something that we've been practicing recently to get him used to showing properties for his clients to take over when he signs up as a subscriber.
So this isn't the first time he's done this?
No.
So I think we should move on to another set of questioning, and that is, the MLS said appointment only. How in the world do you go to a lockbox without scheduling an appointment with the seller?
Well, I was just driving around and saw the sign and the lockbox in front of the property.
So, in your experience as a realtor, have you ever walked in on somebody in an inappropriate position before?
No.
You understand the magnitude of not following the MLS rules and walking in on somebody when they're expecting appointments only, and then you violate that rule, and they're caught off guard.
Mm-hmm.
Would you agree that that's a problem?
Yes.
So what do we do to ensure that the consumer trusts our lockbox system when we have agents violating that blatantly? What do we do?
Read the showing instructions.
Well, personally, I think it would go further than that, and I think it would require some training, additional training. And I'm disappointed that, as a realtor myself, that we would have a violation so egregious as to enter a house without permission. And the seller was in the shower, fortunately was not caught in the shower, but still startled and put in a very awkward position. So not only did they open the wrong person opened the lockbox based on the video, and the wrong person entered the house as the agent, but entered without permission. And it was an unfortunate situation for the seller, where we as a realtor community have lost confidence in our lockbox system, or some have lost confidence in our lockbox system and our procedures. Do you have any more questions?
Yeah, I do. Is it a standard practice of yours that when you're driving around and you see a sign and your clients say, oh, gee, what about this one? And you see the sign, is it not a practice of yours to call up the agent on the sign and say, hey, we're in front of your house. Do you think, tell me about it. What's the showing some instructions? Is it possible, can we get in? You don't ever do that?
No, generally, if they say appointment only, there's not a lockbox there, in my experience. And if there is a lockbox there, it's usually there to access. And if they didn't want access to the agents, normally there's a CBS code on the box.
So is that how you handle your listings? If you have your listings by appointment only, you either don't have a lockbox there or you have a CBS code on it?
Yes.
So I just want to review if we can. So rule violation 9.1, you violated the appointment only. Would you agree with that?
Yes.
Rule 13.6.1, Cheryl did not have permission to enter the property by anybody either. That's also similar to the 9.1. Would you agree you violated that rule?
Yes.
13.6.2, the participant subscriber must be present. Would you think that you were present in this particular case?
Well, I was present close by, but looking back now, I should have been present in the home.
Again, not trying to beat a dead horse, but 13.8 is unauthorized use of a key, which 13.6.1 is essentially a version of that, and 9.1 is essentially a version of that. Would you agree that you also violated 13.8?
Yes.
Thank you. I have no further questions at this time. Do you have any further questions?
Does Joseph Smith, does he not have his own lockbox key?
No, at this time, he's just a clerical user, so he cannot have his key.
Okay.
At this time, I ask each of you to prepare for your closing statements. Each of you has completed a presentation of your case. Is that correct?
Yes.
Yes.
Now, each party may make a closing statement. There is no cross-examination of a closing statement. Complainant, you may go first.
I very much appreciate everyone's time today in bringing this complaint against Cheryl Hara. It was not easy for me or my seller. My hope is that corrective action will be taken by this tribunal and Cheryl realizes the gravity of what she has done. Thank you very much.
Initially, I did not think this was going to be a problem. However, after thinking this through a bit further, I realized I made a very bad decision. I apologize to Haley and her seller for the intrusion on her home, and I want to express my deepest regrets for doing so. I work hard every day to do what is right, and this has been a real eye-opener.
Thank you. Before I adjourn this meeting, I ask you, Haley Garski, the complainant, if you feel that you have had a fair and impartial hearing, and do you feel that you have had the opportunity to present all evidence and the opportunity to cross-examine and ask any questions you have desired to do so?
Yes.
I ask you, Cheryl Ihara, sorry if I mispronounced it, the respondents, if you feel that you have had a fair and impartial hearing, do you feel you've had the opportunity to present all evidence and that the opportunity to cross-examine and ask any questions as you have desired to?
Yes.
Ladies and gentlemen, if there's any further evidence that you think this tribunal should consider, this is your last opportunity to bring it to our attention. If you have nothing more to add, this hearing is adjourned. Following the adjournment of this hearing, the tribunal will reconvene in executive session to render our decision, which shall consist of the findings of fact and the statement of disciplinary action recommended, if any. Copies of our decision will be mailed to all parties. Our decision is not final until approved by the MetroList Board of Directors. Thank you for coming and for your cooperation.
So I did want to jump in here quickly. Hopefully I can get within the camera of the Zoom people. Peace out. Excellent job, by the way. That's actually how it goes down every time. It's like that. And you'll have the opportunity to enjoy the cases as they come as a panelist. Part of the issue that we deal with in training, and it comes up almost every single time when we have the tribunals go into executive session, goes into the deliberation and findings of facts. So I wanted to cover this just in a format where I can read through it with you, and then what I'm going to do is I'm going to pause back to the panel, and Steve's going to run you through it as they actually do. All of these folks have actually done this recently, and some are more veterans at it than others, but they certainly are experienced with it. So the findings of fact is really kind of going back to what Joel was talking about in the initial review, except it's post-hearing. We've had the tribunal, the evidence was provided, the defense was given, and ultimately the panelists then make a determination of what the violation was. And so that's the first part of it, which is the deliberations of the findings of facts. So, as Steve had noted, there were several rules that were noted. They will go through that and they will cite each one. And then most importantly, down at the bottom here is based on the following finding of facts. There's a written narrative of why the tribunal found the individuals either in violation or not of each of the rules in particular. So a very, very key point on the deliberations and findings of facts. After that takes place, a statement of disciplinary action recommended is completed. And this is a complicated document. I will show you, this is what it looks like, but blown up here. Good, I didn't get too many clicks here. But you have a series of steps that the executive session and the tribunal will engage in. And the reprimand, I'm going to go down through these things. I try not to read to you, but this one I do have to read quite a bit of this. But it says at the top, based on the findings of facts attached hereto and incorporating by reference, the tribunal recommends to the board of directors to take the following action. Okay? Number one, reprimand. Placement of a letter, and this is really the authority or the level of action that the actual tribunal can take. Placement of a letter of reprimand in the individual's file for a period of time. Number two, imposition of education requirements. Steve was picking up on that heavily at the beginning there or during the case, and we can, and you do have the jurisdiction to impose individual educational courses or requirements. Those requirements really fall back to the compliance department. In many cases, they've actually sat down with staff and gone through the sections that they've violated. Others might be an acknowledgement that they've read and understood the MLS rules, which again, that then acknowledgement goes in their file. So if there's ever an incident in the future, they say, hey, I've acknowledged and understand all these rules. Well, why did you why did you do it again, kind of thing. The assessment of an all right, the assessment of appropriate fine. The minimum fine for any one rule violation, and you knew that there were several going on here, the minimum fine for any one rule violation is $15,000. That is the maximum fine that can happen at MetroList, but they can rack up a few of those. We've had instances where we've actually laid down fines like that. The individual can actually choose, I think 3 times in the history of MetroList we've imposed fines like that. 2 of them they've paid those fines, and 1 of them they didn't pay it, which basically gains the desired result, which is self-expulsion from the MLS. They just go away. All right. Now they do have a time frame to pay those fines, and if they fail to pay that fine, they can be issued or assessed another fine on top of that. If the fine is not paid within a said period of time. If it's a significant amount, sometimes we work out a payment plan for them. Imposition of probation. It does have a reference to the case number, and it does have a period of time associated with that. And really, probation is really an opportunity for them to take corrective action, not to do it again. We have imposed this a few times with gross violators of the rule or repeat offenders, where we're trying to get them to do the right thing. We can suspend the use of the MLS key box system. So in this case, if that was the action that was taken, they may have access to the actual MLS system, but not access to the key box system. Number 6 is expulsion from the MLS. You're out of here. And then number 7, we also do reserve the right, and in some cases have referred the case over to the Department of Real Estate or the Office of Real Estate Appraisers. We do have appraisers that are participants of the MLS as well. And then number 8, we can actually dismiss or take no action with respect to the hearing. Now, the one last thing I want to add here is that if we in fact had an agent and a broker on the respondent side, and they were found in violation, or the agent was found in violation, the tribunal here has the discretion of doing 2 findings of facts and 2 disciplinary actions required. And that can be imposed, one separate from the other, one on the agent and one on the broker. And we've done that. That has happened almost in every case where there's that combo there. So at this point, I think what I'd like to do is give it back to our well and able mock trial panelists here, and Steve and Paula and Gloria, you're doing a fantastic job. They are now in an executive session on the findings of facts and deliberations. Thank you.
Well, ladies, through this process, obviously, she admitted to violating all of them. So I'm in real life, we have had another violation, and I asked Dave if I could talk about it a bit, where I was not as triggered as they might have been. In this particular case, I'm pretty triggered, right? If this happened and this was a real trial or tribunal, I would, for lack of a better term, I'd be pretty aggressive with how I would proceed. And I just want to make that note. And it's good that these tribunals have multiple parties and views and things like that that take a look at these things. So what do you think?
Well, I think that she's guilty, 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 and then guilty.
So moved.
What else can I say? What her actions and her personality, or about the flippant, well, I didn't think it was a big problem, but the violation to Haley's client is a reflection on all of us, every realtor, because Joseph had the audacity to, when the homeowner said, I want you to leave, okay, I'm going to leave, but let me finish showing, the rest of the house. Shows absolutely no respect for the client or our industry.
That, for me, that was painful, that they would not immediately remove themselves from obviously an environment where somebody was frightened.
And didn't even say, oh, I'm sorry, didn't know you were home. Back out.
I think what disturbs me more than anything on this is she's training a realtor. She's setting a precedent for what other realtors, what her Joseph is supposed to do with his career. And that is, to me, is really disturbing. And to me, that's more where I'm throwing the book at her. Because obviously he's already been trained poorly. He kept going through the house. That's just inexcusable. So if you're training somebody, you should be training them right. She is doing everything wrong. Yes, she was a little bit contrite at the end, but not enough to change my mind. It was too easy. Gee, I'm sorry is just too easy. She needs to wake up a little bit. And if I could have Joseph in here, I'd be doing a little bit with Joseph too. I'm just saying.
Yeah, I think it's unfortunate that Joseph can't be held responsible, because I think he exacerbated the situation by, and whether he knew he was violating MLS rules or not by opening a lockbox without an appointment is a whole nother educational issue. But for him to know that he's in this environment where somebody's frightened and not immediately remove himself, and as it turns out, they were all males. That to me is a great violation of the trust that we as a realtor community need to have.
Yeah.
So let's go through the disciplinary action recommended. So clearly, we're going to reprimand her. Would you guys agree with that?
Yeah, so maximum time.
Okay, so we have a length of time. What would you, so a reprimand is a placement of a letter of reprimand in the individual's file. We must now determine a length of time.
I'd say at least 3 years. I think that's, I don't know if there's a maximum on this, but I would do
Is
a
it,
maximum.
the max is 3 years?
I don't know. Staff, can you come to our meeting and tell us what the maximum is?
This is the time when the door opens and they
Yeah.
come out and ask a question. But yeah, 3 years would be appropriate.
And so when you are doing these tribunals, you do have the right to ask for guidance and stuff like that, and it's encouraged because we want to make it stick, for lack of a better term. So what do you think of 3 years?
I can agree with that.
Done, 3 years. Imposition of an educational requirement. I would leave it to staff as to what education, but I think education is a critical thing here. And I would ask that they complete this in 3 months. What do you think?
Yeah, that's good. I can,
And we can leave it to staff to the appropriate, something that
Yes.
hopefully, I don't know if staff come into the meeting again. Is there different classes that we can apply this as being a more appropriate use, whatever education it is? In other words, is there a class specifically on how to use lock boxes in appropriate times, or is it just a generic class that covers everything on MLS rules?
No, typically when we have a specific violation is we will tailor the class around the violation.
Great.
To make sure that it's abundantly clear with that individual on the action that they're being talked about, that is dealt with in that education. We also throw in there the actual review of the entire rule book as kind of a catch-all mousetrap, if you will, to do that. So typically, that's what the education, we don't have education courses, but the education course is tailored to the event.
Perfect, thank you.
So, number 3 is we have this opportunity, so we'll do 6, we'll leave that to staff,
Yes.
and we'll do 3 months. So, at this point, we have 4 rule violations, and we have the opportunity to issue a fine. And what are you guys thinking?
I'm starting at 5 and going up, so where are you guys?
5 each?
No.
Okay.
let me see. Last time, I can't say that last time, but.
You can.
Last time,
I was less
yeah,
inclined to.
we were ready to throw the book, and Steve was like,
Yeah.
so anyway, yeah, I believe that she needs to be fined, seriously, for it to hurt her in her pocketbook, so she understands, the severity of the violations. So you're saying 5?
I'm starting at 5.
You're starting at 5.
I'm willing to listen to different opinions.
Well, if you want to start at 5 for one violation?
No, it'd be for all of them.
Oh, for all of them?
Yeah.
I think we got to go up from there.
Okay. I'm willing to listen.
I'm willing to throw out $2,000 of
Violation.
Each,
Per
Yeah.
each
violation.
rule?
And we had 4
1, 2,
violations.
3, 4, so 4, so that'd
8,000.
be 8.
I'm good with that.
You're good with that? Okay, I can live with that.
And that is literally how we do it.
Yeah.
We don't get into arguments.
Well, sometimes we do.
Well, and candidly, last time I was, first of all, the broker of record for the respondent was not available because they had switched, and it's a long story, I won't go into it, because there's some, so the kid was left to deal with this on his own, where the complainant had the broker and was very good at presenting the argument, and I just didn't want to end this kid's career, is basically what my debate was. And I felt like we zipped him, we got him, but I hope that punishment,
Right.
was significant enough. And I know that these two felt strongly about it too. We just didn't agree to the fine. We finally did come to a resolution, but it was not as easy as it was today.
Yeah.
Do you have a question?
There is no precedent for certain things. I mean, it sounds so arbitrary.
There could be some precedent. So here's the issue. So part of it is a gut feeling on how do they feel? How did they respond? Were they remorseful? And did they really get that they violated the trust? And so for her, and I love it because I'm so big into agent training, and that's what triggered her. For me, it was the violation of the appointment, and to go into a house without permission and to put in this particular case, a woman in a difficult scenario, alone in a home, and she has now lost the trust of the system. And I don't know what triggered you the most, but probably all of it.
All of it, yeah.
There really isn't a fine list. It's our gut call, and the board of directors can move us up or down or override it, but for me, it's part of our process. Yes?
Question regarding
mentioned that broker of record was not available. Was the broker of record actually held liable?
I can't go in that. I don't think it's appropriate for me.
Because the agent.
The broker of record was no longer available.
Okay.
Yeah.
The agent actually is liable, the broker is liable for the agent.
Okay, are you talking
The
about,
past case.
you're talking,
It's right here.
yeah, this
They're talking about this
case,
case.
he's talking
Oh.
about this case.
I don't know the truth on this. So we get these as a mock trial. I don't know if the brokers showed up for this trial. Normally they would, absolutely. And by the way, if any of you ever had this opportunity to be on the opposite side, please go with your agents. And you're encouraged and begged and groveled, and please go. The agents need you at that time. You need to be there at that time because we have the authority now to go after the broker. So we started the question and answer.
Can I kick in here real quick just before she asks?
Yeah, and we will do the questions here in just a second. I'd like you to hold them to the end because we're in a little bit of a different format with the Zoom group. The Zoom group cannot hear when you just start talking unless we
My
can
bad.
get to you with a microphone. Not a problem. So hold your questions to the end. We're going to be able, Bill and the panel, myself, Veronica, will all be up here to actually help answer those questions that'll be coming up very shortly. So thank you very much. Appreciate that.
So we have five additional items we must make a decision on. So at this point, number 4 is imposition of probation. We can do this much like the reprimand in the file, but we can also put them on probation, providing there's no violation of the same MLS rule as specified in the findings of fact.
Absolutely.
I think we matched the letter of reprimand.
Well, and then also because I get the feeling this is not her first rodeo doing this.
No.
So I'd like to put her on probation, make sure she doesn't do it again.
She'll do it again because it's a standard practice.
That's what it sounds like.
Suspension of the use of the MLS key box system, and for what length of time?
I don't know that I'm ready to go there yet. I think I
I'm
want to see what
in
happens with
agreement with
probation.
that. I think if we can't correct her with the fine, she needs to go sell cars.
When we put her on probation, we have the opportunity to do something
Yeah.
different.
Yeah, and I'll jump in here real quick. So what happens is if we have enough information prior to a hearing that there's been a key violation, MetroList in our rules, the way they're written right now, in our sole discretion prior to a hearing, we can suspend the services on that key. So and we've done that. And then what then happens is their key remains off until they get to a hearing, which the limit for the time for the hearing to be scheduled is how long? 40 days. So from the event, their key could be turned off immediately based off of a testimony of somebody that said something really bad happened. We turn that key off, it's off for 40 days until the determination of the panel of whether or not to turn it back on. You have the discretion also to add on to that. We're going to suspend the key for another 30 days just to continue to do that. That, again, there's no minimum or maximum on that, but there would be that opportunity for the panel to do that. You all to do that when you get there.
So we as a panel have agreed not, did we agree?
We agreed.
Okay. To not suspend the MLS key box at this time. And then the number 6 would be expulsion from MLS. I'm not ready to do that either. Number 7, refer the matter to the Department of Real Estate. I don't think it reaches that level. And of course, we've already made a decision to have some action, so number 8 is we take no action. So for review real quickly, we would like to put a letter of reprimand in their file for 3 years. We would like staff to give them custom training on the violations and the MLS rules and have that completed by the respondent within 3 months. Additionally, we would like to fine the respondent $2,000 for each violation. We find them in violation of all 4 MLS rules. Additionally, we would like to impose a probationary period of 3 years so that if this action occurs again, we may take additional steps to remedy the system. So at this time, we would go in and we'd write that narrative out in a statement of facts, which I don't think we're really going to do today. But This one triggered me,
Yeah.
much more than the last one, but, so I'm, what would you like?
Yeah, you guys, we'll have you come back up.
Okay,
Leave all this stuff.
I'm going to leave it all there.
Hey, and I do have a microphone back here for questions, so please wait for me to hand you the microphone when you have a question.
Hello. Oh, there we go. There we go. Okay, so once the tribunal comes down with a decision, I, within 5 days, send the decision out with the finding of facts and statement of disciplinary action to the complainant and the respondent. Within 20 calendar days, it's working. Okay. Within 20 days after receipt of the statement of disciplinary action, the respondent can appeal. The appeal process, we're not going to go through today, but it is in the tribunal procedure booklet, so you can look at that. After the appeal time has passed and there is no appeal, I then forward the statement of disciplinary action to the board of directors for them to adopt it. If the directors are concerned with a deficiency on the face of the decision, they may refer the decision back to the tribunal for appropriate action. If the tribunal does modify its decision, the parties will be notified of this change, and then they get another chance for appeal. I then process the statement of disciplinary action with regards to the education requirements, fine, letter of reprimand, all of that. Once everything has been completed and the fine is paid in full, then the case is closed. So that concludes the hearing process and what I do, and back to you, Dave.
Okay, stay up here for a second, Veronica. Haley? Cheryl? Where's Haley? There's Haley. Cheryl, come up here real quick. Hey, thank you. So one of the things I do want to recognize, it was easy for most of them, difficult for others, but Cheryl, Haley, and Veronica put all this together, all the scripting. The letters that you saw with the color codes, all that was all their brainchild. So it was really refreshing to have staff take an issue, look at the issue, create a solution to the problem, and then ultimately get that out as a rollout for better understanding and more responsiveness, hopefully from our constituents, our participants and subscribers. So Cheryl, Veronica, hearing administrator, and Haley, thank you very much for a great job. So thank you. All right, you can go sit down. Go ahead, Bill.
Dave, well, if I could add to that, you can well imagine that these ladies in our compliance department, it's not an easy task. Most of the time when the person calls up, they're mad, they're upset, they don't understand that they violated the rule, or they understand they violated the rule, but they think we're out of line by making them adhere to the rule. And so they deal with a lot of difficult people, and they do it with good humor and understanding, and a lot of people don't get the fact that we don't want, the fines from the compliance department is not a profit center for us. We don't want it to be. It's an education process. And so the staff in the compliance department, that's what they try to do. They try to educate first. And then some people just don't want to be educated. And at that point in time, we have to fine. But I'd like a big round of applause because they have a horrendous job. The only other department is when we have people not paying their bill, that it gets some heat. But these staff, Veronica, Haley, and Cheryl, take the heat every day. So big round of applause, please.
Hey, Bill, come back up here, please. Well, this is the opportunity, like any good educational session, you get a quiz. And little did you know that you get the Bill and Dave show as part of the quiz today. So it's been a while since we've been up here in front of you.
And we have the answer sheet. So, yeah, we're smart.
So those of you that are on the Zoom call, you can utilize the chat. We would like you to chime in and try to answer these questions. The good news for you is it's open book and it's all together. So we will enjoy that time together. Immediately following this will be the Q&A. During the Q&A, those of you that are on Zoom, be sure to put your questions into the chat. You can start doing that now. We have staff that is actually monitoring that, and you can pose those questions. And then for all of you that have attended the session today, you will get a certificate of completion today, probably for some of you before you get back to your office. And you can thank Cheryl over there on her computer, because that's exactly what Cheryl's doing right now, is comparing that to the attendee list. So without further ado, here's the questions. Okay, and we tried to do this in the Alex Trebek mode, you know, for 1,000 or for 500. But question number one, what term is used to describe the individual who files the complaint? Anybody?
A member of the public.
What is, whoops, too many answers there. What is the complainant? What is the complaint? Wait, you didn't see that. You didn't see that. All right, Bill, question number two.
Hey, who is ultimately responsible for MLS rules violation?
What is?
Oh, we are doing it at the
Yeah, my clicker is. There you go. What is C? The participant. The broker is always responsible. The participant broker is the responsible party. All right, who may not ask questions during a hearing? Okay, there are some of them that you didn't actually cover. So did I hear B? Okay, that's absolutely correct. It is B. And this clicker is having a hard time. All right, next set of questions. Bill?
What disciplinary actions may be imposed by the tribunal panel? And you got to see a good demonstration of that.
D, all of the
D, yeah, good one.
All right, go ahead, Bill.
What is the maximum fine for each MLS rule violation? What is D? Exactly.
Yeah, what term is used to describe the individual who is named in a complaint? The respondent. Yeah, I heard that over there. All right, very good. You guys are doing fantastic.
You guys are doing fantastic here. Thanks for paying attention. Hopefully all of you in the Zoom have done the same. Hey, what should a tribunal panelist avoid?
I like how you wandered through the answers on that one. The answer is actually A and C. You don't want to discuss the case prior or after. As Steve had stated in the script there, everything is very, very confidential. The other thing I'd like to add here, because sometimes these hearings run parallel to a pro standards hearing, you can't use the findings of anything that happens at a tribunal in a subsequent hearing. So all of that information, that's a question that comes up quite frequently. I know all of you have pro standards training, that type of thing, but the findings of the tribunal are confidential, cannot be used in additional hearings. All right, number 8, may a participant designate an office manager to attend a tribunal hearing in their place? This was not covered in the session today. What is A is the answer, okay? So A and C. So A, so sometimes you have these brokers or these participants that are spread wide and far, and the manager is actually a person that they can designate. If they happen to designate the manager, the participant acknowledges that anything imposed on that manager reflects to them. It is not going to that manager. So that's one of the cautionary statements there that has to be covered. Bill, number 9.
May a complainant or a respondent have legal counsel present at the hearing?
Okay.
That's
Answer to
it.
that is yes.
What is A?
Okay, coming down the stretch.
But and I would just add, and hopefully that's clear, they have no legal standing in the tribunal hearing. They're really there as an advisor to the complainant or the respondent.
Yeah, we had a presiding officer, a gentleman that's very experienced doing this stuff up here, and there was an attorney that came in, and the attorney thought that I think it was one of those you pay as you go attorneys, you pay a subscription and you can hire them. The guy came in and just started attacking the presiding officer, and it was kind of one of those, time out, you're not going to do that, I'm not going to go through 14 pages of whatever you think it is. So they were trying to harass the panel, and they may not do that. It's very clearly stated in the script, but it's not, out of the, chances of it happening are possible at any one of your hearings that you may attend. We will control that.
The sergeant at arms will come in and drag them out.
Yeah. All right, are the tribunal procedures part of the MetroList multiple listing service rules? Yes is the answer. I like that.
Absolutely.
Okay.
May a respondent appeal the findings of the tribunal hearing panel? Yeah, again, very good.
Okay. As a condition of my participation in the MLS, must I have read and understood all of the MLS rules? Wait, all together? Okay, thank you very much. That's absolutely true.
Yeah, and that's that agreement that everybody reads through and signs when you become the application to belong to the MLS.
True story. True story. Did you know that? You guys, we got it in writing. All right. Now it's time for the questions. I just want to, before we jump into the room here, Nicole, do we have any questions from people in the chat? And Bill, why don't you stay up there? We'll share the microphone. I'll give this microphone to Nicole.
Okay, and then I can pass this one around with the people here in attendance. And I still see some stuff back there. I don't know if you want to carry all of that out of here, but, put a banana in your pocket for an afternoon snack.
Okay.
Good potassium.
So at 10:09 from Gary Peters, does the respondent and/or the complaint have an opportunity to reject a panelist for some cause?
The answer to that is yes. If you have a conflict of interest with somebody when you've been notified during the notification process, Veronica will ask you if you have any conflicts of interest. If the individual that's on the panel has a conflict, they can recuse themselves. At that point, Veronica will go back to the list and select another individual.
At 10:15 from B. Simpson, I see repeated issue on MLS, listing I cannot show for several days per listing agent. Example, new listing on MLS Monday, can't show it till Saturday. Buyer found it on Zillow, wants to go today, not wait till Saturday. Is this a violation?
It depends, and in each and every one of those situations, you would want to contact the MetroList Compliance Department, and we will work through each of those individual situations with you on a case-by-case basis.
From Patty Sykes, is there a minimum or maximum for each violation?
The maximum violation or maximum fine for each violation is $15,000. If they go to hearing and there is, they are in violation, the minimum would be $1,000. So it's $1,000 to $15,000 per violation if they're found in violation of a rule as part of the hearing process. We're going to go back to the room. I'm going to throw it back to my buddy Bill. I think Linda Wood has a question out in the audience.
Okay, I see a hand up right there.
So my question was, is a panel always 3 people, the presiding officer, and then the participant, a participant panelist, which is a broker, and then a subscriber panelist, which is a non-broker?
And an alternate of each one of those.
Okay, so that's what it always is the
Yeah,
presiding
that-
officer, one of us who's actually, when we say broker, just has a broker's license, or the broker of an office?
No, a participant in the multiple listing service.
So they would be the person responsible in MLS, and then the subscriber,
And then
one
the subscriber, right,
Okay.
who could have a broker's license,
Right,
but
okay.
is a
But is
subscriber
not the
to
participant.
and then an alternate of
Of
each one of those.
So that's always
right.
the makeup.
And,
Thank you.
and so it's a tribunal, so there's 3.
Thank you. That makes sense. That makes a lot of sense.
What else?
Is it like the SAR tribunals where it's recorded? In other words, are you recorded? Are you recorded?
Yeah, we don't record it, but we have a court recorder taking not a deposition, but a transcript. And if it does go to appeal, or if anybody has concerns about it that has to go back and review it, we would pay a fee and get that transcript from the court recorder. So there is an actual stenographer sitting there documenting every word.
Is that tab picked up by MLS, or is that tab picked up by if they're found, in violation?
If they are let go, meaning if they just they're not found in violation, then MetroList has to absorb that cost. There is a cost there. So when that's taken into consideration, if an individual that's why the minimum fine for anything is $1,000. If you go to hearing and they're in violation of it. Yep, that's the logic.
Okay, it looks like we've got an I'll go over there, or Dave, you got there. I would just add this. We use a court reporter because years past ended up with technical difficulty occasionally with the recording process. And you can well imagine sometimes in the room get background noise and stuff, and so it wasn't very clear. So truly, to ultimately be fair, we have a court reporter and that we use, and so we have a full transcript of the proceedings at that point in time. So I see PJ had a...
The only question I have is how many hearings do you hear a year?
Joel kind of told you that. I think this year we've had 2.
Yeah, we've had 2, and I think we've mitigated 6 others away from a hearing. So we avoided 6, but we went to trial or went to tribunal on 2.
And so it really is not a significant number. As I think Joel had gone through it, to 2 to 4 to 6 a year. With 6, I can't remember in the last 10 years us having more than 2 or 3 a year. So Dave, can you? So yeah, no, let's not have the training you guys out trying to find this stuff, because you want to sit on the panel.
Okay, from Terry Santoro, shouldn't broker and agent be fined?
Yeah, so when Steve was going, the question was, should the broker and agent be fined? Potentially. In Cheryl's case up there as the respondent, she was the broker. And so that's why we didn't have her paired up with her agent. But if there was an agent or a participant and their subscriber with them, the findings of facts and a disciplinary action recommended could impose fines on both individuals.
From Timothy Spencer, would that entail the broker's key suspension and subsequent agent being affected by the broker's removal, I'm assuming lie, to the broker being the responsible member?
Bill?
No, could you...
you read it again.
Totally, yeah.
Would that entail the broker's key suspension and subsequent agent being affected by the broker's removal, lie, to the broker being the responsible member?
Well, we'd really have to review that. If I'm understanding the question, it's in order to be a subscriber in the multiple listing service, you have to have a participant who's in the multiple listing service. And all of you understand that that's the DRE says that the participant's in charge of all of the subscribers, and so we have to have that participant in order to us to be able to administer the rules, the multiple listing service rules. So in a case like that, I would think we would take a hard look at it, and if they didn't have a participant, we would do what we could to, whatever needed to be done. If a participant of brokerage is removed from the MLS, depending on that brokerage, they immediately bring in another participant to take over. But once again, I'd repeat that this would be done on a case-by-case basis. We'd really have to look at that. Dave, do you see it any other way?
Well, no, when we're talking about the $15,000 fines that have been issued by the panel in the past, the broker participant chose not to pay the fine, so the entire office was suspended. So no one in the office under that participant could access the MetroList system or the lockbox system. And to my knowledge, Bill, I know that when the gentleman asked the question, he used died instead of lied. We've had brokers pass away, and then you got to shuttle in a new participant quickly. But in the instance of them not paying a fine or being expelled, that would turn off the entire office.
But we would, at that point in time, do everything we could in our to facilitate all of those subscribers.
Valerie would like to ask how long she's been a broker.
How long Cheryl's been a broker? Cheryl, how long have you been a broker? Cheryl has been a broker for exactly 37 minutes. All right.
Ed, sometime on-market date is different from list date. Sometimes the on-market date must change. How does one do that? Explain DOM.
That's for another day. My email address is dave@metrolist.net. I'd be happy to cover that with you. The on-market date is used, as you guys know, as an unapproved listing date, where you can put a listing into the MLS with a future on-market date up to 120 days out, and then adjust it back and forth. Hold on, Mr. Tanner.
And I would just say, you can call tech support and be quicker than emailing Dave. We do answer those questions. We do have staff available now, actually 7 days a week. Okay, Mr. Tanner.
Going back to the earlier question that we had online, I think what their question was, if the participant is found in violation and the sanction is suspending their key, does that suspend all the subscribers' keys? And I think the answer to that is no, right? As long as the participant's a member, the subscribers
you're
are still
correct.
good.
The key doesn't, in that case, you're absolutely right. We wouldn't suspend all the agents' keys.
One more online, and then we're going to wrap it up.
I got a real quick one, because in pro standards, once you've decided somebody has committed a violation of some sort, you can ask the staff if they have been found guilty of something prior to this, because that comes into play on what you're going to do as far as fines or whatever. I'm curious, does MetroList have a system like that where you can find out were they guilty of crimes before, of violations before?
Crimes are crimes. Yeah, yes, we do. And please don't be offended, but we call them gross polluters. And so, yes, we keep track of that, and that's why in the finding of facts and disciplinary action, it says that if they violate it within a period of time, then, other things kick in. So absolutely, that's correct.
Yeah, and Bill, I'll add something that part of what Veronica does as the hearing administrator is when a individual comes to a hearing, she looks at their member file. And if there is any prior stuff in there, she provides that to the tribunal.
Okay, so we do have two and one unmute, but the really quick one from Jane is, thank you for all your efforts by putting this on by the staff. Will there be a recording available?
Yes, we have a recording. It will take a little editing, obviously, but the answer to that is yes. We're going to offer it up as a recording to those who have attended. We also will have follow-up training for those who could not attend. If you had individuals that would have liked to have attended this but could not for whatever reason, please reach out to the compliance department at MetroList, specifically Veronica as the hearing administrator. And when we have the follow-up training, we will be sure to notify you.